See how I do under pressure?
You're live.
We're nice here.
Sometimes.
Well, thank you very much for having me. Glad I did show up a little bit early. So my name is Bob Audi. I had asked to testify today for a couple of reasons. One, so I'm president of North Country Sportsman's Club located in Williston. I'll talk a little bit about the club in a moment, but also as someone who will be impacted by the bill should it become law. Primarily want to make sure that I get through the Sportsman's Club portion of this, so I'll talk about that first. So a little bit about our club, like I said, located in Williston. We've been there since 1962. We have about 120 members at any given time, and we're also open to the public. We're a shotgun only club and participate in a number of different varieties of quick target shooting type of sports, catering to recreational shooters, competitors, as well as hunters getting ready for the various bird seasons in Vermont and things like that. We also host a number of hunter education courses and partner with Vermont Fish and Wildlife on some other activities and events throughout the year. There was some discussion on this bill in House Judiciary, and I haven't seen it here yet, so I wanted to sort of bring it to light. Possible that I missed it, but around the effect that particularly the safe storage portion of H230 may have on sport shooting ranges. I think there was some discussion there about whether sport shooting ranges would be obligated to be responsible for the safe storage of any firearms obviously brought on site by attendees, or even those that the the club itself might own. Again, hadn't heard that discussed here yet, primarily because of what I interpret to be the emphasis on the custodian of the premises, the custodian or of the premises. So I wanted to, I guess, maybe even just open with a question of whether it is also this committee's interpretation that there would be some obligation or responsibility on the part of the shooting range, and then the road forks pretty hard in the discussion from there, depending on sort of the answer
I
to that.
believe beyond the
Yeah, and I will admit to having a bit of an epiphany on this question just this morning as I was sort of reviewing the bill and my notes one more time, because under that, I'm on, I believe, the current version of the bill, page 4, line 7, where it starts with prohibition. A person shall not, within any premises that are under the person's custody or control, store or keep a firearm, ... Would the bill require that the person is both the owner of the firearm and the person whose custody the premises is in? Or is it one or the other? Or, like I say, both? Because I think those are some important distinctions in the context of a shooting range, and maybe even others. If somebody brings a firearm to my home, am I, as the homeowner, responsible for the custody, the control of their firearm? Should it leave some of the other, close control and things like that that are already provided for in the bill? So,
yeah, I believe you would be, the homeowner would be responsible if they were aware. But the way the bill is written now, the House version, and the way that it's going to be rewritten, I think it would be clearer that there is no penalty unless, and I emphasize unless something goes
right. Yeah,
So,
unless the firearm is acquired by a child or a prohibited person, and something bad happens as a result. Yeah.
So I do believe that anything that's in your home, we didn't want to, I don't think the House, and I know we didn't want to get into cars and other storage, other places where it's against the law to have a loaded gun in the car, I believe.
Loaded rifle. I believe actually a loaded
rifle.
pistol is okay.
Yeah.
Yeah,
That's right.
they're more concerned with the hunting aspect than the protection aspect.
Thank you for.
So, just a conversation about the intent there, and if there is not an intent that this would extend to shooting ranges, far as I'm concerned, that's good news. And I would just maybe ask for some wording as you do your markup and things that would further clarify
That
that.
may be something we should.
Yeah, that would be, I'll just say, I won't read all of my
I mean,
comments.
even though, I just saw statistically that one of the largest places where criminals acquire firearms is in cars, glove compartments.
It's not hugely surprising.
This nature. Yeah, not necessarily. Anyway, please go ahead.
Okay, yeah, so so I'm glad to hear it. If that truly is the, both this committee and the House intent, I know Eric was obviously in a lot of their conversations. I don't know if he has a different take on what their intent was, but hopefully a discussion that can be had around whether this took place. That would be a fairly large burden, I will just say, on sport shooting ranges, just because of the way that we're staffed, the way that our facilities are laid out, and just the way the operations generally occur. So I'll just leave you with that then. The other thing related to shooting ranges, and I will sort of tie this back, is, and I may actually ask for Eric's confirmation on this, is that I've watched a fair bit of the testimony both in House Judiciary as well as Senate Judiciary on this bill. And when the initial walkthrough was done here in Senate Judiciary, I think there may have been an honest misstatement. There were some questions, I think maybe from Senator Baruth, on the deferral of the 72-hour waiting period specifically for gun shows and the sunset, I think on July 1st of 2024. There were some questions around that. And I think that Eric had said that House Judiciary's intent there, right, was that it would give gun shows sort of a year to acclimate to this new reality, and also in the meantime, possibly allow consideration of some sort of process to waive the background check, I think was your comment. And I sort of remember that. I'll pick on Senator Baruth for a minute, because I think you had a rather visceral reaction to that. The word may have been insane. I think the word used may have been insane. But I think, and Eric, maybe you can confirm, or maybe there were discussions I wasn't aware of. I think the intent there was to allow a year for the possible creation of a process that would allow current gun owners to waive the 72-hour waiting period. Is that?
I don't think so.
We've not had any discussion of that.
Not here. I think that was, I think you had asked the question about maybe why House Judiciary, or the House, I guess I should say, may have included that. But I don't think there was an intent to waive the background check for current gun owners. I think the discussion that I heard there was around a possible waiver of the 72-hour waiting period for current gun owners.
Right.
I'm uncomfortable with even, we're dealing with the language as came to us from the House.
Sure.
I don't know. Nobody's talking about waiving background checks, or if we pass a waiting period, then waiving it for some.
Yeah, I don't think the discussion here, but I think,
I gotta step out.
again, possibly, I think if you go to committee or something like that, or not committee, conference with the House, maybe something to have a discussion around, because I think from what I've seen of their conversation, that may have been the intent of that year-long deferral.
But if they didn't put it in the bill they sent us, and we don't put it in, we wouldn't conference and add it, if that makes sense.
On that topic, you mean?
On any
So you would only conference on,
what you close the
Substantive
difference
changes.
between the two
right?
pieces. You don't add things that neither had chamber pass.
Mhm. Yeah, okay. So that's procedural, but I understand.
In other words, they may have had discussions about things that didn't make it into the bill, but the overriding reality is it didn't make it into the bill.
Well, and maybe that's part of if that was their intent, the year-long deferral would only allow for the opportunity to discuss such a provision.
Sure.
Not necessarily to guarantee its implementation
Sure.
or inclusion, as presumably as another bill.
Senator Vohosky has a question.
Yeah.
Yeah, I mean, I guess no, it's fine. My question, if we're not changing the bill to include any type of exemption, my question can wait until we are.
Yeah, and I think that my interpretation of their discussion was not that they intended to include that in this bill, but that year would give the opportunity to sort of have that discussion. I will just say that such an exemption for gun shows, even beyond the year, or some sort of an exemption from the 72-hour waiting period for current gun owners would be, again, I'll tie this back to shooting ranges, but would be a significant, would be important for gun shows within the state. I think that it's been already testified that gun shows become somewhat less, of an attractive event if you would need to return to a different location several days later to acquire your purchase, from again, different location. And where I will tie that back to shooting ranges is that some of the bigger gun shows within the state, at least the ones that I'm familiar with, are put on by shooting ranges as a part of how they fund their operations and kind of keep the proverbial lights on, or maybe literally keep the lights on. And so anything, just kind of wanted that statement to be clear, as well as, any consideration around actually taking that up, and whether it be a requirement of this bill or somewhere else that hopefully the Senate and House can sort of work towards something that would allow gun shows to essentially operate much as they do today, kind of for the benefit of the shooting ranges. I think that may have been largely my comments. So yeah, really just asking the committee to consider including provisions in H 230 that don't place additional burdens on shooting ranges, maybe a moot point if the intent wasn't that it would apply to them. And to also, like I say, on the gun show side, as that affects shooting ranges potentially. I did have a few comments around some of the wording, just as sort of an individual stepping back out of the shooting range role, unless anybody wants to stay on the shooting range topic for any longer.
Floor is yours, so whatever you
All right.
want to talk.
Yeah, so just in reading through the bill, I've obviously kind of gone down the rabbit hole on this and trying to, read and understand and follow the progress of the bill. And I think that the more I've sort of read the bill, I commend the authors of it for trying to keep a lot of it in sort of plain language. I think in this case, some of the plain language, and again, you can see Eric's feedback on this, but I think some of the plain language in the bill hides some legal definitions that are substantively different than sort of the plain language definitions of some of the words and phrases that are sort of included there. Just by way of examples, the bill refers to child pretty much throughout. And I will acknowledge that there is a good and very objective definition of child in the definition section of the bill, if you make it that far. For someone who may not make it that far, I don't think, for example, of a 16-year-old necessarily as a child. And as I was sort of reviewing my wife asked me last night, what are you going to go down there and talk about? And I mentioned this as one of the examples. And before I could even mention anything about the word minor, she said, why don't they just use the word minor? So I don't know if there was a reason for that, but that seems to be, at least in our interpretation of it, possibly a word that would clarify, again, in the absence admittedly of getting as far as the definitions, who those sections of the bill would actually apply to. So just submitting for consideration whether minor may be a better word to use there. Maybe there's a good reason not to use minor. I don't know. I just wanted to raise it as a possible point of clarification. The other one that I sort of dug into was prohibited person. So I think the majority of people will understand the word prohibited, and the majority of people understand what a person is. And I think most people also understand that there are some people who cannot or should not own or possess firearms. I think when you wrap that all together, because compliance with the bill will require an understanding of some of those criteria, it has the potential to get a little bit foggier. Those of us who have purchased firearms have filled out that Form 4473, and we understand it runs you through a series of questions. Are you under indictment for a felony? Are you an unlawful user of drugs? Dishonorable discharge from the military? A number of criteria there. What wasn't apparent to me, and I guess still is, and I probably will go and do this research, is whether those are the only criteria that may make someone a prohibited person, or whether all of those criteria make someone a prohibited person. So if you are going to make a decision on how you store your firearms, based on whether somebody is a prohibited person, I think those criteria and those definitions become quite important. And I'm not sure, there is in the definition section a bit of an explanation on prohibited persons. I found it to be very high level and generic, kind of along the lines of some people shouldn't own guns. This person shouldn't own guns, keep a gun out of their hands. But again, what are the criteria that would put someone into that category? I think there would be the most benefit from having that clarified within the bill itself, but I noticed that some other definitions simply refer out to either other state laws or federal laws that would more thoroughly define that. And so I think some clarification around who is a prohibited person and what criteria, like I say, kind of put them into that category may be beneficial to those, should this become law, seeking to comply with it.
As I told you during my emails with you, given that this is almost the end of the session, I hope we can wrap up testimony in about 15 minutes. And I'm sorry I missed part of yours, but I had to get out.
No problem. I have most of this. I mean, I am working off of some notes here, and so I can
wrap
up.
That would be helpful.
Yeah, just two more terms that I would just suggest maybe some clarification around. The reasonably should know term. I know Eric gave an explanation of this in House, if not Senate Judiciary as well. The thing that still wasn't clear to me is, does reasonably should know require the gun owner or the controller of the premises to make an effort to know, right?
No.
So what's that?
Reasonably should know or should have known is very common language throughout.
So I do not necessarily, if I'm not aware that, this person who's visiting my home just got out of jail, I don't necessarily need to ask.
I didn't know somebody that was in my house was using drugs.
Yeah, I asked Eric a similar question, and I thought he made it pretty clear that it's.
Okay, yeah, the only part that wasn't clear to me was like the effort, right?
The reasonable person standard, which is well defined in law.
Yeah, I think I had asked about would I be required to run a background check on everyone visiting my home, and Eric.
Actually, I do remember that, because I remember thinking that, like, unless you hold a federal firearms license, you can't run a background check. So, yeah. All right, well, we can set
At my
that.
age, I think some 30-year-olds are teenagers.
I was going to make a joke about, I don't think of 16-year-olds as children, but I do think of some 30-year-olds as children. But, and the last one that I would just like to suggest some clarity around is oddly enough, the term likely that is in the bill. So again, having sort of gone down this rabbit hole of some of the legal meanings of plain language terms, made an effort to try to determine what the legal definition of likely was, and there was sort of a stunning lack of agreement out there on that. Legal definition seems to, in my interpretation as someone who's not a lawyer, run the gamut from a reasonable person understands that something could happen, all the way up through what I think is the more plain language understanding of sort of the 50% plus one standard, right? More likely than not. And so whichever definition seeks to be interpreted in this bill, just a clarification around what that would mean in this case, because I think there's a lot of daylight between understanding that someone who visits your home could access your firearm versus they are more likely than not to access your firearm. And again, deciding how to handle and store firearms as a result of an intent to comply with the bill. So those are my statements. Again, I know you're trying to wrap up and move on to others, but happy to answer any questions on either of those points, and I'll forward the notes that I have prepared along. I think you've clarified some of them, so some of them seem a bit irrelevant in hindsight, but that's what I came in with.
Thank you very much. I don't know if there's any questions for the committee, Mr. Ali. Mr. Ali, thank you very much.
Yeah, thank you all.
Thanks for being here
me in.
early so that we could.
Well, it was my first time. I wanted to know where I was going and get there in time.
I'm going to take Rebecca Turner next, and then John Rogers. Senator John Rogers.
Good morning, committee. Rebecca Turner from the Defender General's office. For the record, I apologize for not being here
No
at 10 a.m. I was at the
problem.
Supreme
We'll
Court.
try to wrap up like 15 minutes.
I'll have
If you were at the Supreme Court, then that's a fine excuse.
Supreme Court and misreading my calendar. I thought this was a 10:30 again, but I'll take advantage of being at the end to sort of fashion my comments based on what I heard. I heard most of the testimony. I've heard a lot of good questions. And I've also been here on a different bill on the Second Amendment. And in fact, today I wanted to not focus my comments to this bill on the Second Amendment ruling, but I am going to focus on just Section 3, and that is the safe storage section of this bill. And specifically, I want to focus my points on what Section 3 is doing, is creating a brand new felony offense, based on an act of omission, not properly storing the firearm as directed. So an act of not acting, right? That is the criminal act. And I look at, as an appellate defender, what is the minimum mens rea required to sustain a 5-year felony conviction? Now you have knowing, but you also have at the bottom, is it reasonably, it's a negligence standard. So it's an objective standard. The person does not actually have to know that there is someone who is within the class of people who shouldn't have access to these things. You don't have to know. You reasonably should have known, but you don't personally have to know. You don't have to act. It's an act. It's a failure to not act. Failure to not act. You don't have an actual criminal negligence. And it's still not a crime, right? And I understand that it's only a crime if that group of people who are not prohibited from having access actually commit certain acts, and therefore that triggers your third-party liability for someone else's actions without bound to time, so they can commit those prohibited actions at any time in the future. I don't see in this provision within 5 years of accessing these firearms, within 1 year, within 20 years, within 50 years. How long is this? Statute of limitations is usually a normal way of limiting expected liability of criminal liability. But here, the triggering event that makes this a crime doesn't occur until the third party, the child or prohibited person, does the act. So when can that happen? To me, now you have taken and combined all the elements of a crime and placed it in a straight and clean due process violation. Due process violation, not just because you have several vague terms here, and you've heard even testimony this morning, how it's not readily apparent for non-lawyers to understand it. We've heard testimony from others. I'm not talking about that due process violation, but I can talk about the specific terms that concern me on fundamental vagueness. I'm not talking about notice issues, right? That's related to it. But I'm talking about the limits of the legislature's awesome and incredible police powers to create crimes out of previously innocent conduct. Now, there have been challenges to the legislature's limit to create these crimes brought up to the US Supreme Court. And here is where we come back to what I started with. Mens rea, actus reus, what's the act being criminalized, what's the mens rea, and then third party liability, and what's the degree of punishment. Are you talking about a fine only? Or are you talking about a felony? And a felony here in Vermont is, of course, more than 2 years. Here, it's 5 years. And so I can run down, I testified briefly at House Judiciary, these same concerns, but the very big US Supreme Court decisions on this, limiting the police powers of the legislature to criminalize just any innocent conduct. And here I think you've crossed the line on several fronts, on the mens rea, negligence linking it to a felony, 5-year punishment. The act is not an affirmative action, right? It's just not acting. And then making it not even a crime until someone else does the act that you can't control by time or anything. And so there, I just want to put that on your radar that as written, this is a violation of due process.
So let me ask you a couple of questions. Number one, would you prefer the House Health and, well, whatever, Human Service, whatever they call themselves, committees making everybody a crime and making it a crime for everybody who doesn't properly store their firearms. And then you get into how the hell do you enforce that by going into everybody's home and checking we might as well check their composting compliance at the same time. So you could do that. You could do what the House Judiciary Committee could do. You could do what New Hampshire and Maine did. How is this any different from what New Hampshire and Maine have done? Are they violating the same standards?
So I heard your questions and interest in New Hampshire's legislation. I forgot to look at Maine's. I printed out New Hampshire's. New Hampshire's is narrower and I think is not as, there are different problems. The penalty is a fine only $1,000. This is, I'm looking at New Hampshire statute section 650-C-1 titled negligent storage of firearms. And it copies a lot of the exceptions that I see here, a lot of the, and then the premise, but it's only targeting children, not prohibited persons, right? So it's narrower in scope. And child is further narrowed to be under 16, not under 18. So I put that out there. So just fundamentally, it's capturing fewer.
I don't know. There's this negligent storage of a firearm.
Yes, and the mens rea is the same. It certainly allows for the reason we should have known. So it allows a mens rea of negligence. But there, instead of it being linked up to the 5-year felony, they have it linked up with a $1,000 fine only, no imprisonment. Now, so strict liability offenses have been challenged up to our Vermont Supreme Court and upheld. Again, one of the things that the court looks at is what is the attendant punishment.
So you're thinking that if it's $1,000 fine, like New Hampshire, then it is constitutional?
It is certainly not on its face unconstitutional. You're now in the realm of where the Vermont Supreme Court has upheld strict liability offenses because you're now in a fine only situation. So yes, and I don't want to take up the time, and I'm happy to come back to talk about what the Supreme Court does to analyze strict liability offenses and whether they're constitutional. But it's a very simple, straightforward on this front, that's what they look at. The other interesting aspect of New Hampshire is that they allow that even though this is triggered when 16 and under are known or reasonably should have known to be on the premises, they allow for further exceptions that this section 4 doesn't. That if a parent, another authorized guardian of this child gives permission, then that doesn't apply. If this child has completed firearm safety instructions by a certified firearm safety instructor or has successfully completed a certified hunter safety course, now this is removed from liability. Again, recognizing that perhaps a guardian or parent of this child could give permission, or recognizing if the concern is firearm safety, that if the child has shown compliance with certain instruction, then that's an exception. So again, narrower in scope in terms of the possible liability reach.
My understanding is that the intent is to prevent the impulsive action of suicide and community violence. And I guess I'm not sure how hunter safety prevents that.
And I don't want to speak to the policy goals and whether or not there's a nexus. I do want to share, and that I just shared that in terms of what is the differences I see.
Okay.
I see that fundamentally the New Hampshire statutes is with narrow in scope of captured activity, which then again, as you narrow this scope, you avoid perhaps overbreadth or due process vagueness, notice potential challenges, in contrast to what I see with section 4 language. Let me just shift to the specific language that I think is I want, so the testimony that I've heard shared here is that this is a narrow statute, that it is not overbroad. I actually think that this is the opposite, the very opposite of a narrowly proposed legislation, and it is absolutely not clear. And I'm going to give you a sense of that here. Dropping down on specific terms used here, prohibited person, again, a class of people carved out to where someone has to safely store. Prohibited person by definition is someone who's prohibited by Vermont or federal law. When I follow that down and try to understand that just in the federal law context, I'm brought to what we know as the Brady Act, 18 USC 922, lots of subsections. In other contexts, we've heard about how federal courts around the country are interpreting Bruin, and there have been challenges to that federal law prohibiting people from possessing firearms, the various subsections. You've heard us share how various district courts, less than a handful of appellate courts have reviewed this. The courts are splitting as to whether you can be a prohibited person from possessing of firearms consistent with the Second Amendment. I will point that out only to share how you have opened that door of instability and more confusion as to what a prohibited person is.
I think I see what you're saying. I view it differently because the definition says if you're prohibited under state or federal law, you're prohibited. So if the Supreme Court strikes down this or that state or federal law, then that definition holds, and that definition shifts as the Supreme Court shifts. Whereas had we taken the previous witness's advice and articulated all the prohibitions, then we might have a bill that would be out of date or out of sync with Supreme Court decisions. But as it stands, I think the definition is set to move with whatever the prohibitions in state.
If the Supreme Court decides that people who are convicted of domestic violence can have firearms, they would no longer be prohibited persons.
Right, and this definition would still be fine.
I wanted to share too that this has been presented here in the committee, but the Second Circuit hasn't yet ruled on this issue. Now, post-ruling, that is certainly the case, but as recently as 2021, and for the record, and I can share with Eric Fitzpatrick on the case name, United States v. Perez, Second Circuit 2021 decision determining whether a prohibited person under that statute includes certain non-citizens from possessing firearms. Certain non-citizens, not just unlawful immigrants without lawful status, but also certain non-citizens in lawful immigration status. So I'm just giving you a category, and the Second Circuit considered, can you peel out and prohibit under the Second Amendment, consistent with Second Amendment rights?
But do you see my point about,
That
you're talking about an instability currently, definition of prohibited person. And so there will be changes clearly at state and federal level about who's prohibited going out, let's say 10 years. But this definition just ties it to whatever the current moment is. So if the Supreme Court strikes down, the idea that people convicted of domestic violence are prohibited, this definition doesn't need to change because state and federal law has now changed, and this syncs with state and federal law immediately.
I understand. I wanted to just point out that the Second Circuit has actually answered something that is already said it had, and so that's that the people within the Second Amendment concerns all people in the context for viewing it with non-citizen class carve-outs, right? So that is just, I want to highlight that there is not so much instability on the question of who is the people in terms of the meaning of the Second Amendment. So I just wanted to raise that Second Circuit decision hasn't.
I still don't see the conflict for our definition.
Because Section 4
Yeah.
carves out, not just prohibited person, but carves out children under 18 from having access, seems like a lower status access to firearms, not equivalent to others. Right?
So if I understand your concern, the two, one is New Hampshire just deals with the child, doesn't deal with prohibited persons. Second, New Hampshire creates a misdemeanor, $1,000 fine. Vermont creates either a misdemeanor or a felony. And those are two of your concerns with the constitutionality of section 1 after all the findings. So that, I've looked at New Hampshire extensively and believe it's, That's what I'm interested in your concern. So those are two decision points for the committee as we do our version of the bill.
I'm sensitive to your time. I realize you're past 10:30.
Any, no, I've received probably 200 emails saying that Rebecca Turner said it's unconstitutional. And I just so you know, you're quoted widely
Yes.
in terms of the constitutionality of the House passed version of the bill.
And again, I say that from the perspective of how I would be approaching
Yeah.
and representing the client. And I think that it is useful for this committee here, at least perspective, a legal expert's perspective on constitutional law of this proposed legislation.
Great, thank you
Thank
so
you.
much.
Thank you.
Appreciate your patience with this committee and finally getting the.
Well, and I'm sorry finally that I messed up on the.
No, you
time.
didn't mess up.
Time's a charm.
There's
You have to
times
be
for
with the
charm.
Supreme Court, you know, they take precedence.
Thank you.
Our next witness is Senator John, our next and maybe final witness, formal witness is Senator John Rogers from some of the Glovers. I don't know if it's east, west, or north or south Glover. Welcome, John.
Thank you, Senator Sears. It's West Glover. And
Okay, I'm glad I got the directions correct.
I appreciate getting an audience with the esteemed committee after a fashion. So thank you for having me. As those of you who know me might guess, I have some issues with this bill. I believe, as it's been pointed out by others, there are parts of it that, from my perspective, are clearly unconstitutional. But I have some other issues, and I'm going to just start with the findings, some of which I seem to me to be a little misleading or vague when we refer to in subsection 9 of the findings. In 2016, there were 51 traces of firearms involved in the homicide in the state of Vermont, and it doesn't specify how many of them are legal or illegal firearms. And I really think that that's relevant because, as we know, many of the shootings and firearms crimes are done by people who are not supposed to have firearms, and they are done with firearms that are illegal. Also, when we go down to subsection 10, and it refers to all the numbers that can be traced back to a known purchaser, trying to present the case that there are a lot of straw purchases happening in Vermont and the guns are used in crimes in other states. But I don't believe there's any evidence as to whether these guns were actually purchased that day and transferred to somebody who was probably dealing drugs, or if it's a firearm that's been in the possession of that person for many years or that person's family for many years, and because of their addictions and other maybe financial problems, they traded off their grandfather's gun or the gun that their dad gave them when they were a kid. And so I just feel that some of the findings numbers are quite misleading, and I know that there's a lot of different feelings on findings in our bills. And so I'll start with the waiting period. I find the waiting period is something that I could possibly support if it was only for first-time gun buyers. But it really seems silly to me to make a person who already owns firearms and therefore is not purchasing a firearm to commit suicide because they already have that ability. I'm not sure why they should wait. I see a hand up.
Yeah, I'm wondering with an exemption like that for people who already own firearms, how someone would prove they already own a firearm. We don't have any kind of permitting or registration system, so anyone could go in and say, I already own a firearm. I
think it's quite easy. When you buy a firearm, you get a bill of sale with it. You could bring in your bill of sale. I shop at a couple different gun stores and have bill of sales on guns I purchased previously. You could bring a gun in. We could create a system where gun dealers could give people a card that says, I'm a gun owner, I've purchased from such and such a gun shop. I think there's a lot of ways to go about it. But from my perspective, like if I'm in the Waterbury area, I enjoy stopping at Perro's gun shop. And if I see, I don't buy a lot of new guns because they're quite expensive, and I don't have a ton of money to throw into a huge gun collection. But if I see something that is an older gun in a model that I like, or something strikes my fancy and it's reasonably priced, I may purchase that firearm. And I've stopped in there and done exactly that in the past. But if I have to go back 3 days later, then I won't even stop into that store. It makes no sense for me to drive over an hour one direction and to retrieve a gun because of the waiting period.
Yeah,
Senator,
oh, sorry.
no, go ahead.
Yeah, I guess, I mean, without a system of actually tying a gun to me specifically, I may have bought a gun before from the Powder Horn, which is local to me, but because we have private transfer, I might have sold that to my brother and no longer actually have a gun in my possession. And now I don't see a way without a registration system that ties the firearm to me and is updated when there's a transfer to actually prove that I currently have a gun in my possession. So
Well, there's one way that's pretty concrete, and that's to walk in with a gun in your possession.
John, good to see you.
You as well, Phil.
I miss having you around. I will say on this issue, you and I tend to disagree. Couple of things. The idea that we would write into law, bring your gun in and show a gun and you won't have to have a waiting period, seems to me the whole thing we're trying to prevent, which is people carrying guns around and showing them in this or that context. With that said, you mentioned Perro's gun shop and range. There was just an incident a couple weeks ago where someone went in, rented a firearm, shopped for 40 minutes, and then turned the gun on themselves and killed themselves with it. That's one of the things we're looking to address, is suicide by firearm. But it's not the only thing. And so I think the House bill tended to put a lot of emphasis on the suicide piece, but the waiting period has another function, and that is a cooling off period for people who want to turn the gun on others, not themselves. So somebody might have a pistol, but experience tells us that when a mass shooter is preparing, they often go out and buy specific weapons to use the next day or the day after in the shooting that they have planned. So the 72-hour waiting period isn't, in my mind, the fact that somebody already owns a weapon, it doesn't negate the effect of the cooling down period for that particular person. Not to mention Senator Bohofsky's point about how you would ever prove that you're a gun owner without a registration database.
Well, and back to my point that you could walk in with a firearm, and under the Constitution, it is legal to carry that firearm. And if I'm going there to purchase a firearm, I'm going to walk out with a firearm. And I totally understand what you're trying to get at. And none of us want weapons in the hands of dangerous people or people who are contemplating suicide. But this, clearly the waiting period is going to eliminate gun shows. There's no reason for people to go to gun shows if they know they can't buy a gun. And I've been to a gun show before in Morrisville and bought a gun from a dealer from Brattleboro, and I'm certainly not going to travel down to to Brattleboro to purchase a firearm. And so I just think the waiting period is putting an undue burden on law-abiding gun owners for what some believe will be a small help. But I grew up in this state, and before we started adding any gun control measures, for most of my life, it's been the safest state in the nation. And I like to believe that most of the state is still safe, although I know you have a lot of random shootings in downtown Burlington, but I would dare say Bennington
As well, John.
too, yeah. Not in West, not in West Glover, not in West Glover.
I understand West Glover, but I don't represent West Glover. I represent Bennington.
Yeah, that is true. But I believe if anybody did the research, most of those people who are shooting are not probably supposed to be carrying firearms anyway. And a lot of the firearms were purchased or traded illegally.
Understood. Senator Bahalski, and then I want to move on, John, because we're trying to keep it to 15 minutes.
Yeah, I just have a question about current law because I don't know. I am lucky that my local gun store is just 10 minutes from my house, so it's not hard for me to go back. But I've also heard testimony that you can order firearms on the internet and have them delivered locally. Would there be anything stopping someone from going to a gun show in Brattleboro and going home and having that gun shipped to their local gun store for pickup?
I think Eric Fitzpatrick is probably the one to answer that question, not myself. But let's not forget that all of these things add cost to gun owners, and cost is a real issue for regular people.
As one of those young people that can't really afford to live here, I certainly understand that. Eric, can you answer my question?
I'm not sure the answer on the top of my head.
Okay.
I'm sure. I think it's a federal.
Take a look at it.
Okay.
John.
Okay. Yeah, so I'll
Rest of
move
the
on
bill is
to
okay?
to safe storage. I have all my firearms in gun safes unless I'm using them. But the language in safe storage says you need to keep your ammo separate from your firearm, which I find absolutely ridiculous. It's like having an empty fire extinguisher, and when your house catches fire, you go get the fire extinguisher filled. I have several firearms in the safe beside my bedroom that are fully loaded and fully locked up. And if I need a firearm for something, it's easily accessible with a code, and I can get in, and that's the purpose for having firearms. And I tell people all the time, I don't think my house is going to burn, but I do have a fire extinguisher. And I hope to never have to use a firearm because someone's breaking into my home and threatening my family. But if such a thing happens, I am prepared. And so this has already been found unconstitutional by the Supreme Court, I believe. And so I would ask the committee to remove that section from the bill, as I believe it's unconstitutional. And I know that when we take our oath of office, we do swear to uphold the Constitution.
The wording, there's an exception on page 4, line 15, that the subsection shall not apply if the firearm is carried by or within such close proximity that can be readily retrieved and used by the owner or another authorized user. In other words, if you're keeping it next to your nightstand and you're right there, as I read that, then that's not, you don't have to keep them separate. I understand what you're saying. You're locking something up and then you're putting the ammunition separate from the firearms. And you got it locked up. Why do you need to separate it? That's your question.
Right, exactly.
But there is that exception in the House bill.
Well, I guess from I would defer to legislative counsel, but my interpretation is that my firearm in my safe is not it's in my safe all the time, whether I'm in my bed or not. I don't unload it every morning when I go to work. It remains there, fully loaded in my safe.
If your firearm is safely secured, why do you need to take the ammunition out? That's your question.
That's my question.
Good, good question.
Well, thank
As
you.
as the committee does its work on this bill, it's another decision.
And then my other question about safe storage would be like around the farm, if I'm having trouble with pests in crops, I often have firearms either in my truck or in my tractor with me, and I'm not exactly sure how that would fit into the legislation.
Doesn't change. I don't believe it changes that at all. You're not in the house, on the premises.
Okay, well, thank you. I guess those are my main concerns. I agree with Senator Sears that in emergency relief, it should be clear and convincing, as stated before. None of us want violent people to have firearms and do bad things with them. I think one of the things that bothers me, and back to the straw purchases, about the discussion with firearms showing up in other places, from my perspective, the majority of those those guns end up in the hands of drug dealers and drug traffickers who are bringing poison to our state. And we know the huge problems we have with addiction and death by overdose. And it's a little bit disturbing to me that some folks seem to be more hung up on the fact, first off, they're getting the guns illegally. If they're taking them back, they're already violating Vermont laws. But in my mind, the thing that we could do to prevent Vermont gun deaths is focus more on those drug dealers that are bringing the poison into the state, than focusing on the guns that they're already illegally taken out of the state.
I don't disagree with you. And S4 actually repeats federal law so that it can be enforced in Vermont on straw purchases as well as ghost guns and defaced serial numbers. So the Senate already took care of that. I don't know what the House is going to do with S4, but I don't think straw purchases are an issue that needs to be addressed in here because it's already been addressed in S4. And I might add, there was no discernible opposition. Well, there was a little opposition, but I don't think there was a lot of opposition to copying federal law on straw purchases and defacing serial numbers. But we'll see what the House does with S4. I'm sure they're having a time with it.
Well, thank you all for giving me a few moments, and
thank you. It's nice to see you, and we'll look forward to seeing you down here.
John,
except for Senator Baruch, doesn't look forward.
John, I just wanted to say, you remember your speech on S55, and among other things, you talked about drones, and we all shook our heads. Why is he talking about drones and the need to shoot at drones? And now I see what's happening in Ukraine, and I thought John Rogers called this years ago.
Hey, don't you remember I sent you that piece on drone swarms?
Exactly.
Very disturbing.
Yeah. All right. See you soon.
See ya. Take care.
Thank you. Okay, Eric. We're going to take a 6-minute break.